Okay, well, good evening, everybody. It's 5 o'clock, and so let's get started. Welcome to CondoVirus episode 2. This being the second episode, I like to call it the Empire Strike Back episode. Now, before I get flooded with emails, I realize that the Empire Strikes Back is not the second episode, but if you were born when I was born and if you saw the original broadcast, it is. It is the second episode. So welcome to the second webinar that we have on COVID-19 and the pandemic and the impact it has on condos out there. For those of you who are new today, joining us today for the first time, I mean, we have nearly twice as many attendees as we've had in the past. What we've done is we've struck together an industry-wide crisis prevention cell made of experts in various relevant fields, and I'll introduce them to you in a minute. And our objective is to try to share knowledge and is to try to share information to help condo corporations navigate through these difficult times. I'll introduce the panel in a minute. You'll recognize most of them, but I want to start by saying a few things. While we do our very best to provide you with accurate and timely information, the nature of the topic being covered is such that the information is stale dated the minute that I've uttered the words. I mean, the situation changes on a minute by minute basis sometimes, so do keep that in mind if you're going to watch this broadcast later on, because we'll upload it on our website. Keep also in mind that with respect to the legal information we provide, it's really focused on Ontario. We have people from coast to coast right now, and you'll get very good information today, but when it comes to the legal information, keep in mind that it's Ontario-centric. Also keep in mind, please, that there's as good and as intelligent sounding as we may come across, the reality is that there's nothing like getting actual advice from your actual advisors. So whether they be lawyers or auditors or property managers or whoever it is, get information from these individuals to give you actual information that's applicable to your specific situation. And finally, and I know it sounds like a disclaimer, and it is a disclaimer because I'm a lawyer. I'm going to say this is that keep in mind that this is being recorded right now. Okay, now let me introduce the panel and then we'll move on. And I'm going to go in no particular order here, but I'm going to start maybe with Denise Lash from Condo Law. Good evening, Denise.
Good evening, Rod.
Hey, good evening. Sandy Folds, good evening.
Good evening.
Hey, nice. Okay, and we have Graham McPherson from Gowling, WLG.
Hi, everybody.
Okay, and then we have also, you know what, let me show you the list of, I already skipped a few of my jokes. Let me have this is the list of who we have online. I need to do two things at once, speak and control the PowerPoint presentation. So Brian Antman, are you there?
Yes, I am. Good evening.
Okay, very good. Good evening. And then Sandy, we dealt with you. Catherine Go, are you there? Can we get a sound check from you, Catherine?
Nice to see you tonight, everybody.
Thank you. And then we had Denise Graham, and then we have David Plotkin from Gowling WLG as well. Good evening, David.
Good evening, everyone.
Okay, so the last thing I wanted to say before we move on is that some of you are familiar with this, but there's a channel, there's a chat channel that you can activate and you can use that functionality. There's also a question and answer channel. We would really encourage you to use the chat channel as opposed to the Q&A, because if you use the chat channel, everybody else gets to see your questions and whatever comment we put and whatever answer we give. Whereas if you send us a Q&A question using the Q&A channel, only we get to see it and only you get to see the answer if we ever get to that. Graham is going to be monitoring the chat channel, mainly Graham and David, and so if there's any sort of interesting questions or interesting suggestions, we'll try to bring it up, cover today. And so the first one is going to be a bit of an update. And let me start with this, with the update. On Monday, both Quebec and Ontario, and other provinces, but both Quebec and Ontario on Monday, shut down every a non-essential service. And that came a bit as a shock wave initially, because in Ontario, certainly when it was declared, we didn't know what was going to be included in the essential services. And so for about 5 hours, we weren't too sure. And you have to understand that while the pandemic is affecting everybody in every sphere of society, the reality is that it's affecting condominiums tremendously. In Ontario, we have about 12,000 condominiums. These need to continue to operate. They need to continue to provide essential services to about 1.6 million Ontarians. These condo, of course, provide housing services, but they also provide water, electricity, sewage services, garbage pickup, safety and security. And so we were quite concerned as to what would be included in that. Um, and many of these corporations, what they do have is that they have also employees. They have concierge and superintendents and cleaners and managers on site. So it was very important for all of us that all these services be declared essential. And I don't mean access to the LCBO essential kind of service. I actually mean essential services. These people at the very heart of providing safety and security for all owners. So a couple of hours later, Ontario did hit the nail right on the head. And this is what it provides for. And I can't read because I see people's faces. I don't know if there's a way for me to hide that for a second. There it is. And so as an essential service, it includes services providing support and maintenance service to buildings, including urgent repairs, anything that's related to the safety, the security, and the sanitation and the operations of a building, including property management. All of that is considered an essential service in Ontario. So that's good news. If there wasn't enough pressure on your property managers out there, now you know you are essential, if there was any doubt before. Let me start this. Now, very briefly, maybe I can turn to the panelists to give an update on the various, let's start with various bodies that regulate the industry. So let's start with the Condo Authority of Ontario. Is anybody giving us an update on this, David or Graham?
Yeah, sure, I'm happy to. So with respect to the CAO, the latest update from them is that they continue to try and implement their digital service model as much as they can. Their online resources and services are remaining active, including the free director training courses they offer, online condo filing return system, their public registry, and their guided steps to common issues, and the Condominium Authority Tribunal. They continue to support the few remaining condo corporations who have not yet filed for 2020-2021 returns with the CAO. And although they state that legislated deadlines remain in effect, they recognize the unique circumstances and are taking measures to support condos during this difficult time. In addition to the 25% assessment fee reduction that they've already implemented for the year, they are also indicating that they're suspending late fees for any condo returns until June 30th, 2020 for now.
Okay, that's good news.
Yeah.
David, can you provide an update on the Condo Authority Tribunal? Are you the one dealing with that?
Graham's going to grab that one as well.
Yeah, I'll steal his thunder on that one too. The Condominium Authority Tribunal, or CAT, is remaining open and available, and users can continue to file new applications and participate in active cases with them. What they are doing at this time, I think, is managing it on a case-by-case basis with the parties already involved in active cases, and sort of putting it to the parties and deciding amongst themselves whether they want to put that case on hold for the time being or how they want to proceed. But for now, unless the parties agree otherwise in a case, it's business as usual for them, which is, I suppose, the benefit of running an online tribunal.
Right, very good. Catherine, do you want to give an update on this ACMO's? And I think you have a few slides here for this.
I do, just a couple. Of course, the ACMO office is closed so that all of our staff members can stay home and stay healthy and support the social distancing actions that have been recommended by public health. They are all working remotely, and so we're available to answer any questions. They are also posting fast and furious information about COVID social media posts that are good, solid information that you can share with your communities. You'll find a great deal of excellent information that you can use and share within your communities there. So I encourage you to go follow that. They will be hosting a webinar as well. The other thing that we have been doing is advocating on behalf of the profession and managers. We have some concern, particularly if the closures last for a very long time, that it can negatively impact upon the ability of transitional general licensees in particular to accomplish all of their required educational goals. We had also hoped that the CAO and CMRAO might take actions not unlike Tarion to defer some of the regulatory deadlines that we have. And we hope to hear more on that in the future.
Okay, make sure you stay close to your mic, Catherine. Sometimes it gets a bit weak, but I think we got it. Sandy, you want to give us an update on CCI?
Sure. CCI is continuing to educate members as relevant information is released. They've begun compiling resources from industry experts on a broad range of topics, including sample notices. This information is all available in the Resource Center of the National CCI webpage. They've also begun work on submissions to various government departments for major condo concerns, including extensions of deadlines and risks related to condo fee deferrals, lien registrations, and that type of thing during these times of financial hardship.
Okay, very good. Denise, can you update us on the CAI and also tell us what the acronym stands for to make sure that we distinguish all these acronyms?
Thanks, Rod. CAI Canada is a chapter of the International Organization of CAI, which is the Community Associations Institute. And the reason that it's important right now to just let people know about this organization is because it's an international organization. I think what managers and directors may find helpful is going on to the international website, which is through the U.S., and it's caionline.org, Community Associations Institute. What you'll find there is information. A lot is in the U.S., but it's helpful to know how the U.S. is dealing with this, and we can apply a lot of what they're saying to our current situation.
Okay, wonderful. And the last one, the Condo Directors Group. So we went from CAI, which is international, the Condo Directors Group, and is mainly located in Ottawa, but it's basically a forum by and condo directors for condo directors. And what's good about this one, if you go on their site, condodirectorsgroup.com, is that they are posting information from all sorts of other websites, and so they're not sort of limiting themselves to whatever resources they have. So you will get to see there all sorts of various blog posts from various legal bloggers. You'll get to see info from ACMO, from CCI, from CAI, and so that's a good source of information. Okay, now let's dive in and focus on real practical answers and on some of the various questions that we faced so far. Let me see if I can change the slide. We're going to focus on quarantine, and we're going to give you an update on that and on how that is applied in real life in various condominium corporations. And I guess as by way of introduction, I'm going to say this is while the governments are rightfully pushing people back home to implement social distancing in public spaces, when you're pushing people back home, well, in condominiums, it has a tremendously different impact than if you're pushing them back home in suburbia. So if you push people back home in suburbia and everybody's in their single dwelling, well, that's one thing. In a condominium setting, everybody is living on top of each other. Everybody is using the elevator highway. Everybody is transiting through the same common elements. And so that provides for a very distinct set of problems that need to be addressed. And the issue that we see here is that while we're imposing social distancing in the public sphere, we may be doing this sometimes at the detriment of social distancing required at home in condos. Think of the sudden spike in deliveries in condos. People are getting all sorts of things delivered home now, food and amenities and toilet paper and whatever it is that people need now, they get that delivered home. Think also of the fact that some residents at home, they need to get their family members to come and help them or visit them, or a nurse or a PSW. Think also of owners that wish to continue to do renovations in their units. So all of these are problems that you don't encounter in suburbia, but we do encounter here. So let's dive in, and let me maybe start by turning to Catherine about board meetings and all these owners meetings. What's the approach with respect to those? How are managers tackling this now?
I think everybody in condo land has moved to online meetings in order to support social distancing. It's also a way for everybody to stay healthy through everything that's going to happen here. We mentioned last week, if you do have somebody who insists on attending the boardroom, I've had managers set up the conference call in the boardroom so that that person, perhaps they don't have the ability to do so in their home, they can attend in the boardroom, frankly, by themselves, but at least they will be able to get the content. For annual general meetings, I'm concerned about the ability to meet the intention of the meeting, which is to have open discussions with homeowners and votes and things of that nature. So those are being deferred, and it is an action that is supported by condominium lawyers and also by the CMRAO at this time, and until those public health advisories have been lifted.
Okay, keep close to your mic, Catherine. Sometimes we lose you a bit, and so I've turned your camera off just to make sure that we have a better sound quality. Okay, very good. David, did you want to add anything from the legal front, I guess, maybe?
Sure. Just from the legal front is mirroring a lot of the practical considerations that managers are having to deal with day to day. It's just, especially with AGMs, holding them now is almost impossible and certainly unadvisable. Trying to set up remote AGMs for everyone who have not everyone has the same technical capabilities. Not everyone is able to manage on Zoom as we all are, and it's just very difficult to hold these meetings now, and it's definitely advisable to push them off if possible.
Right, and that's the approach I think that's being taken across the board, is to postpone meetings that are not absolutely essentially required. And I mean, it's going to be touch and go for a little while. It may be that I think for the foreseeable future, you don't want to hold AGMs, owners meetings. You don't want to circulate rules at this stage of the game, because that may trigger a requisition that may lead to the requirement of having to hold a meeting. I think at this point in time, it's best not to. And in fact, holding a meeting now, certainly in Ontario, would actually be contrary to the directives that are being pushed down by the province. Okay, how about if we switch gears, because it's going to be rapid fire, because we have a lot of topics to cover here, and I'm going to ask maybe Sandy to talk about protective equipment or protective measures that are being put in place to protect employees and concierge and superintendents. What can you tell us about this, Sandy?
Sure. So under the Occupational Health and Safety Act, we do have an obligation to keep all of our building staff safe. It's a priority for us all at this time of social and physical distancing. Unnecessary contact with occupants and visitors needs to be avoided. If an employee believes there's a condition that will endanger them in the building, they have every right to refuse to go to work. Removing unessential staff from your buildings who can easily work remotely to do their jobs should be considered. In-person contact with an on-site administrator or sometimes a manager is really not necessarily required. All resident contact can easily be done by email or telephone. Hopefully you all have databases for easy email communication with your residents. Now, concierge desks in your lobby are a regular area for close contact. Some are now installing plexiglass shields where possible, but this takes time to order and have installed. An easy, quick option that many are doing is to mark out a 6-foot space on the floor with tape just in front of the desk, just your personal space. Managers and superintendents, however, can still conduct inspections of buildings and common areas while limiting contact with other residents to ensure all your life safety systems continue to operate as they should. As this illness progresses, however, we will need to plan for reduced staffing in all aspects of our regular daily operations, particularly for superintendents, cleaning staff, security, and concierge services. Managers should be speaking with their companies responsible for these services to work on contingency plans.
Okay, thank you very much. Denise, I'm going to turn to you now with this very specific question. How do we deal with infected units or returning snowbirds, and how do we deal with that? What kind of challenges have you encountered so far?
Well, I don't have the easy answer. It's a very difficult issue. What we're seeing now are residents are coming forward and advising management if they've been in contact with someone with coronavirus or they themselves have the coronavirus. They are coming forward, but they don't have to. And of course, management can't force residents to divulge that health information. So we really don't know if there are people in buildings that have the coronavirus, but the ones that are coming forward, what we are recommending is that notice goes out to residents advising them that either somebody has coronavirus or they've been in contact with someone who has coronavirus and they're in isolation, and just keep the owners informed. Everybody is in panic mode right now, and you just want to calm everybody down, so you need to communicate that. What you don't want to do is give private and confidential information, which is the name or the location of the unit. And the other thing, and questions I've been getting, is about residents that have traveled and they are not going into isolation or they're not telling management. We're saying management doesn't need to know that information. That really is a public health issue. You can't be expected to know every resident that's traveled over the past 2 weeks and keep that information. Now, what do you do if an owner refuses to self-isolate? And we've had this issue, and corporations have tried to contact the police, and the police, unfortunately, as of today's date, are not really doing anything about it. They'll do it on public property. They'll go to that person, and perhaps there's some kind of something that they can do with that person, but when it's on the common elements in the condominium, they won't touch it. I've been told that perhaps if you go through public health, that public health may authorize the police to enter onto the common elements and to do something about it. But as of today, we don't have that mechanism. So what can you really do if you're concerned about the safety of your residents? We've got the mechanism under Section 117 of the Condominium Act. We know that the courts are closed with respect to certain matters, but if it's an urgent matter, that can be done. I'm not sure how quickly you can bring a Section 117 application, but if things get really bad, there is a mechanism by which you can do that.
Right. And one of the questions that came up on the chat line is in light of today's federal announcement dealing with implementing mandatory quarantine and so on, how does that impact a manager's obligations or duties? And at the end of the day, the difficulty we have is that owners are entitled to move about in the common elements. That's also part of their property. And we need to balance privacy, and we also need to balance safety. The reality is that condos are not equipped to implement quarantine, and they don't have the powers to do that. And so I think what I take away from what you presented, Denise, is two things: balancing privacy versus safety, providing accurate information and verified information to help people take steps to protect themselves. I mean, if you know that someone in Unit 306 is a known person to be infected, you're not going to disclose that necessarily, but you absolutely want to make sure that people in the corporation know that there's such an issue, that there is such a risk, not just a vague risk, oh, be careful, generally speaking, and wash your hands, but an actual risk. Because in my view, if you don't convey that information, you're exposing the corporation to some liability. And I guess the second thing I got from what you've indicated, Denise, is that you know, I guess when all fails, the tools that the corporations have may be to rely on Section 117, which is the provision dealing with dangerous activities. So, I mean, if there's an individual that's causing or behaving in such a way that's causing a dangerous situation for the rest of the condo corps, I guess that's when you'd be able to potentially go to court, keeping in mind that right now going to court is challenging. They're back on they're down to skeleton sort of staffing.
Right. I just want to also mention that you have to be careful because notice is going out to all the residents. You want to make sure that your information is verified. So if there's a rumor that somebody in Suite 302 has a coronavirus, you do not send out notice. And I think that's obvious, but I just want to remind everybody, get confirmation from,
Right.
from that individual themselves.
Okay, and I see more questions coming in, but they're being covered a bit later. So let's switch gears and let's now deal with closing of amenities. And so there's all sorts of amenities in condo corps, fitness rooms and party rooms and gyms and pools and saunas and whatnot. Sandy, how do managers tackle this on the ground right now? What do you do with your amenities?
All right, so as we discussed last week, all of those amenities should now be indefinitely closed. Your corporation board members and managers are obligated to take reasonable steps to mitigate potential risks. Cleaners must now concentrate on cleaning high traffic areas repeatedly throughout the day, including doorknobs, handrails, and elevator buttons, not the amenity rooms. Owners also need to do their part because it is really impossible for your cleaners to have those surfaces perfectly sanitized 24 hours a day. It is impossible. You need to wash your hands after touching every public surface. Carry hand sanitizer, carry wipes with you. Those are options. Guest suites in your buildings also need to be closed. It's not a time to allow guests into the building for extended periods. Common area washrooms should also be closed to all except employees who have no other facilities available to them while they're working on site. Laundry rooms. Now this one is a hot topic and you will need to address this with input from your solicitors. But the general comments are that considerations for residents in self-isolation or diagnosed with COVID-19 should be completely prohibited from using these facilities. However, healthy residents will need to do laundry during the period of social distancing, so perhaps limit the number of residents permitted to be in the laundry room at any time, or disconnect some of the machines to provide for social distancing. Some corporations.
And by that, sorry, Sandy, and by that, the example you gave, I guess, was every second one or every third one.
Exactly.
Just to put that space between individuals. So if every second one is disconnected, well, obviously you have more space. Okay, go on. Sorry, I interrupted you. Go on.
No worries. Some corporations have been receiving special requests as well to use amenities for owners with disabilities. These issues need to be addressed on a case-by-case basis in consultation with your solicitor. Don't try and handle that one yourself. And we've seen a few chats go through asking about owners who don't want or who want refunds for not being able to use their amenities. Legal opinions are consistent on this one. Refunds are not required. You do not have to give anyone a refund for this.
Okay, and Denise, maybe from the legal perspective on that, on accommodating disability and on whether or not we need to reimburse common expenses, what can you tell us?
Well, I think Sandy is spot on there. Nobody's reimbursing any common expenses right now. In terms of accommodating someone with a disability, we have been asked these kinds of questions. They are sort of one-off requests for things like access to the gym because someone needs it for their disability. And we have, the Human Rights Code, and it still applies. And it does impose an obligation to accommodate that individual. But, I mean, these are difficult times, and how do you do that? Just because they want requests to the gym doesn't mean you have to provide access to the gym. But what you should not do is really deny the request outright. You really want to work with that resident and see how you can accommodate them. And it may be that there's something like exercise bands that you can put in the unit that they can do. So what you need to do is sort of brainstorm with that particular resident, come out with a resolution. If you need to ask for further medical information, you can, but at this point, we're saying try to work with the resident and do your best to see what other alternatives can be made.
Right, right. And Sandy talked about guest suites. Denise from Lash Condo Law, can you tell us a bit about short-term rentals and how to deal with those?
Oh, okay. Well, that's also another interesting one. So a lot of corporations do allow short-term rentals. And right now, notices are going out. Most of our clients are doing that, stating that as of today's date, short-term rentals are prohibited. That doesn't mean that you kick people out that are there right now. Let them stay in, but advise residents that no new bookings. And this is really consistent with what they're doing in the U.S. They've got short-term rentals, and there's also timeshares. Same prohibition. And of course, the basis for doing that is Section 117 of the Condominium Act, if anyone has an issue with it. What we have found, which we were really concerned about, is that short-term rental providers were using this as an opportunity to get people that are self-isolating, people with coronavirus, to go into short-term rentals. So you could have your units in your building for that purpose, almost like a hospital. So it's really careful and it's important, and I think there's a real strong basis for prohibiting short-term rentals.
Yeah, I think so. Catherine, I'm going to turn to you now with respect to access to units. I mean, at times access to units or to suites are required either to do some common work or or to respond to an emergency, a flood, a water escape, whatnot. What do we do now in the current circumstances? How do we deal?
I believe really firmly that you're going to only be entering suites when you have an emergency. And by an emergency, I mean a flood, a fire, or a risk to human life. And where that is absent, I hope you're deferring that kind of work. And that's for the protection of your staff, of the contractors, and for your residents. When you do absolutely have to enter into the suites, everybody will be using what they call universal protections, and that's social distancing of 2 meters, and that's hand washing before and after you enter into the suites. One of the things that we talked about is, goodness forbid, you do have somebody that you know is self-isolating, self-monitoring, or has tested positive, and you have a water leak. That's the thing that happens most often. What are you going to do? And I would recommend, again, you're going to try to mitigate the damage. The next slide, which popped up there for a second, is a slide that shows some of the most common isolation valves that are found in suite. It wouldn't be a bad idea, if you haven't done so already, to circulate this type of information to your homeowners so they know what they're looking for, and ask them to identify where they have their shutoffs in their unit. It's a good practice all of the time. It does mean that you might be able to book somebody through it over the phone in a worst case scenario. The other options are, and it's the type of thing that seasoned building operators, superintendents, and property managers know, is that you can isolate water from a higher source above, from a further down the pathway, riser-wise source, if that's what you need to do as well. The intention being to ensure that your staff members and the contractors are safe while they're still attending to an emergency. The other thing that plumbers tell me is, Catherine, I have my hands in dirty drains and toilets all day long, so I'm pretty good at some of the self-isolation moves and some of the things that I would need to do to sanitize. I'm concerned also about resident health. So in a community transmission circumstance, what we're trying to prevent is close contacts so that we don't get transmissions.
Mm-hmm. What about asking owners to retire in one of their bedrooms while you go in or someone goes in to do some of the work? Is that a precaution that you've dealt with? Is that one that you implement?
Absolutely. And so it's to get as much distance as possible, particularly because we don't know for certain if somebody is positive or is not positive. And that way, both for the safety of the resident, as well as for the contractor, and for any security officers who may be attending with them as well. So you're trying to give everybody as much distance as possible when you're doing a suite entry these days.
Okay, thank you very much. Anybody else wants to add anything to this one before we move on? So nobody being, okay, that's great. Let's move on then. The next topic we want to tackle is work in suites. And I mean, so we have people that are now self-quarantined. They have to isolate for up to 14 days and maybe a bit longer than that. And soon enough, they'll get bored of each other and maybe of the decor. And so some of them either want to do some work in their units or they want to complete work in their units. Some of them had commenced work in their units. And so to allow this work to continue, the issue or the challenge will be this, is that you get contractors that are transiting through the common elements and taking the elevator highways again. And so there's just that many more people interacting with each other. So how do we tackle that and what can we do about that? So I'm going to first give a bit of background, I guess, on how Quebec and Ontario have approached that. In Quebec, they've defined, in the construction industry, they've defined essential services as being limited to construction work that is required for safety and security purposes. I mean, if you need to go in, if you need to repair something, in Quebec, that's an essential service, so that's not being shut down. In Ontario, the language is far more generous, and in fact, they're not limiting as essential services work that's required for an emergency. In fact, in Ontario, I mean, if you have a hammer, well, that's it, you're considered essential services. And that may create some challenges for condo corps, as I said, because some people want to continue with their work. Catherine, what can you tell us about that? How do you approach this?
I think, unfortunately, you have to do so a bit on a one-by-one, a case-by-case basis. Majority of my properties have already notified homeowners that they won't be approving of any renovation plans or proposals during this time and until such time as the emergency is lifted. And those that are ongoing, the property manager's been directed to get in touch with the homeowner and find out at what stage they are in and if they're in a stage where they can safely stop the project and forestall it for a period of time. And that is for everybody's safety. Where that can't take place for a variety of reasons in terms of where they are in the project and or when they need to move into that newly renovated space, the property manager has met, reviewed with the crews that are working in this space, all of the universal protections that ought to be carried out, and gotten them to affirm that they are healthy and that they will notify if they have any concerns that the property manager should be made aware of.
Okay, and we go back and forth between the slides because the order of the presentation has changed, so don't worry. I know that somebody's wondering about the moves in and move outs. We're going to talk about that in a minute, don't worry. Denise, did you have anything to add with respect to that?
Yeah, I think Catherine did such a great job, but I thought it would be useful to give you an example of a situation, because I just had it yesterday. It's quite amazing, I'm getting these questions. So we have an owner who started the renovations. They're 60% complete. They're living in another condo unit in the building, which they have to move out of May 1st. So what do? Do you allow them to complete their renovations? And Catherine really said it all. Should they finish the rest of the renovations or not? Is it essential for them to do that in order to move into the unit? Those are the questions that you have to ask. How long will the rest of the renovations take? We don't know if in a week from now there'll be some further order that may change the essential service category. So right now we're saying it may be that you go ahead and you authorize that owner to complete it, depending on how long. And also what's important is the protocol. The entry and exit, the owner should make sure that they ask the right questions to their contractors, that they follow the public health guidelines, because everybody needs to be kept safe.
Right, and in fact, many corporations may already have the tools required to deal with this. Many corporations have, either as part of their rules or in cases as part of their declaration, some language that allows a corporation some level of discretion over what kind of work can be done, when can the work be done? How can the work be done? And we've advised some of our corporations recently on that very specific question. We pulled, in that case, it was in the declaration, and the declaration provided that any and all work in units had to be approved by the corporation, and that the work had to proceed pursuant to whatever conditions and terms were imposed by the corporation. So in such a case, it's easy for the corporation to say, well, now is not the time, and we're not going to authorize this kind of work. Also, if you don't have that language, you may be able to turn to a higher level of authority. You may be able to look at your municipality, the public health officer of your municipality may have pushed down some directives. An example is here in Ottawa. The directive is that a non-essential work in multi-residential buildings is not to take place now. So have a look at your city, have a look at your province. Are they providing any sort of directions which allows you to prevent or delay or control or monitor the kind of work that will take place? And again, it's not to make people's lives difficult. We are trying to preserve the greater good and the safety of and the security and the health of many individuals. And so unfortunately, that sometimes requires some individual sacrifices. The reality has been decades since Canadians have been asked to put the collective interest before their own personal interest. It's been decades, probably since the Second World War. And so, I mean, it's going to take some getting used to for all of us, I'm sure. Let's see here where we're at. Anything else? I think we've covered pretty much everything about the kind of work to be done. Let's talk about move-ins and move-outs, and let's talk about deliveries. Sandy, are you the one tackling this?
I've got deliveries, yes.
I'll volunteer Graham to deal with move-ins or something. Go ahead with Sandy with deliveries.
All right, so at this stage, to protect your staff, only essential deliveries should be permitted at this time to your buildings, which includes food and healthcare products. Residents should be discouraged from a lot of the regular parcel deliveries that are coming into your buildings. Really not needed at this time. Many delivery companies will no longer deliver beyond the entrance of a building to protect their own staff. So your building does need to establish policies on how to deal with deliveries. Your security and concierge staff really do need to remain in their lobby areas to protect your building, unless you have many staff members available, at which time, sure, one of your staff members can be running around the building, dropping off deliveries in front of your residents' doors. But if you have limited staffing available, or in some cases, no staff at all, which is often the case in a lot of the high rises that are not in downtown Toronto, you've got a few issues that you need to deal with. You know, of course, healthy residents can definitely come down to the lobby to get their deliveries. That's not a problem. But if you have self-isolating residents or residents who are confirmed COVID-19 patients, an option is to consider having a neighbor-to-neighbor program set up in your building where you've got a group of healthy, essentially bored residents who volunteer to deliver items around to other units and just leave them outside of the unit door. That is a good way of keeping people who are isolating in their units where they should be. These isolating residents also should not be going down to the lobby to pick up their mail. Not the time to be wandering around the building. These policies, the board needs to clearly and repeatedly explain these to the residents by email, by notices, however it's best to be done in your buildings, but the owners need to be reminded.
I think it's a great point, Sandy, and I also believe, you know, as Mama always told us, you get more flies with sugar than with vinegar. Sometimes if you have a resident that you're concerned about who isn't self-isolating, to try to reach out to them and offer some assistance, you know, drive them towards that volunteer group who is doing deliveries or some other resource. In Toronto specifically, there's a company who's taken on food deliveries, particularly for elderly, self-isolated people, and their folks are garbed up so they can be safe. I think that's a great practice. In terms of what I might recommend for the volunteers, for the people who are, you know, graciously taking deliveries, taking garbage, you know, running errands, I don't know that the special precautions, so to speak, are any different from what they're telling everybody, and that's very frequent hand washing, and that's a lot of social distancing. So where we would never allow somebody to leave something in the hallway or leave garbage in the hallway, if you've got a specific schedule so you can facilitate that kind of social distancing with some volunteers, I do believe that that would be a better practice than having them go into the suite and share the same airspace with them. So I think that might be a good way to manage that kind of a situation in a longer term.
Okay, and I saw you react a bit. Graham McPherson from Gowling WLG. Do you have anything to add to that with respect to deliveries and with respect maybe to, go ahead.
Well, with respect to deliveries, I agree completely with what Sandy said. I think there's kind of two schools of thought on how to best do it. I mean, is the best way to have deliveries brought all the way to units and dropped off at the door, or does it make sense to have owners come down and pick them up at the front door of the building? And obviously that's going to be subject to what the delivery person is willing to do. But I tend to, I think, lean in, I'm no epidemiologist, so take this for what it's worth, but I tend to lean towards trying to remind owners gently and frequently that the best policy is probably to have the meals or deliveries brought to owners' units to prevent multiple owners from congregating in the lobby at the same time, and prevent just too much use of the common elements, which we should all be trying to limit as much as we can. And then
right.
the
challenge of course, the challenge, Graham, with this is whether or not the corporation has the resources to offer that kind of service. Right. Okay. And you were going to add something maybe on the volunteer groups. Is that where you were going?
Well, yeah. Just with respect to volunteer groups, I mean, I tend to think that it's probably the best practice for the corporation to leave this as something for neighbors and unit owners to do amongst themselves. But if the corporation does want to get involved and does want to, play a role on this, it may be something worth looking into to have waivers in place, just, because that's the world we live in. And if the corporation is going to be taking on a leadership role, it just wants to make sure it's adequately protected.
Okay. Catherine, can you cover move-ins and move-outs? I think you were the one covering that, I think.
Yeah, it's a popular topic. And Denise and I, when we were talking in our plenary sessions, we're talking about the fact that you certainly won't be able to prevent somebody from moving into a home, especially when they don't have another home to live in. In some ways, I think sanitizing the elevator after a move is easier than sanitizing it all day long, right? It goes on service for the move. It's at a planned and scheduled time and location. And so you've got some control over those types of items. The other things that they do have now are some sanitation products that live afterwards, so keep things clean afterwards. The question of whether or not we're sanitizing units, I guess, comes from my condominium background, where the unit doesn't belong to me. It belongs to the homeowner. And so, would I be taking any action at all in terms of sanitizing a unit? I wouldn't. And that's because it isn't the condominium corporation's responsibility, perhaps in my view, to look after the sanitation of the suite itself.
Okay, and you raised the question of elevators, and I saw Sandy react here. Do you have elevator protocols in place? How do you help people navigate through these troubled waters?
I'll start, and then Sandy, maybe you
Sure.
can jump in as well. There's a lot of questions in the forum about social distancing in the elevator, which can be challenging, especially if you're in a very large condominium. To get a meter between each person in the elevator can be challenging, although it is recommended. Some of the things that my managers have been sharing with me are really neat ideas, recommending toothpicks or Q-tips to press the elevator buttons instead of using fingers. And that is, of course, because disinfecting wipes and things like that are becoming fewer and far between. And that's something, until recently, until this webinar, Q-tips and toothpicks were really easy to come by. And so something that they're starting to stock themselves so that they can have them available, and is maybe a good idea. Sanitation products, there are lots of new ideas around fogging machines, all kinds of sanitation programs that managers might want to look into with their boards. I'd be more prone to use a product that survives on a surface, and there are several of them if you're using a fog machine with something that, you know, has the same lifespan as a disinfecting wipe, I don't know that you're doing anything different or better. And the cost, I think I know is more substantial.
Okay, Sandy, anything
Sure.
to add to that, or?
Just that residents really should take turns and wait for an empty elevator before, you know, them and their family get in. Don't jump into an elevator that already has 3 or 4 people in it, because that's totally defeating our social distancing principles.
At
Right,
the end of the
right.
day,
And
as much as possible, it's staying home to stay healthy.
Yep.
And it is, as you said, Rod, it's difficult for us to get our heads around. We've never had this kind of a request for restrictions on our freedoms and our ability to go wherever and do whatever. But it is what's necessary. And it's mostly not for me that I would be doing that. It is mostly for people who are aged, and it's mostly to preserve capacity in our healthcare system.
right, right. Now we're getting far too many, far more questions than we can handle on the Q&A, and I see that Graham and David are trying their best to sort of answer some of these questions, and some of them are yet to come, our answers, so we're sort of ignoring those, and some of them were covered last time, but we're going to do our best to see how many of these Q&As we can answer. This is it's very, very relevant questions being asked. But we're sort of running out of time here, unfortunately. Let me move on to the next topic. The next block of topic is all about budgets and finances, and you've probably been wondering why we have Brian on the line, and he hasn't said a word yet. And so this is where we need your expertise, Brian, and help us navigate through these difficult financial times. I mean, I'm expecting increased expenses for corporations, and I'm also expecting owners to find themselves in a very difficult financial situation. Some may lose their job, some may be laid off temporarily. And so how do we deal with all of this? The reality is the corporation needs to continue to operate. So can you help us, Brian?
Sure. So the first thing I'm going to touch on is there's been in the last little while a lot of discussion about increased costs, people deferring their fees, and as a result, perhaps corporations having to revise their budget. So at the outset, a budget is set really at the beginning of every fiscal period based on information from the property managers, based on actual historical results, and what costs are anticipated in the future. Boards have to be cautious that their obligations to maintain the common elements are met, but a board does have the authority to change a budget midstream. I would suggest that there's very specific circumstances that I would recommend that to be done. So for example, there may be some corporations that have a large accumulated surplus or a contingency fund. Basically what the revised budget would do would reflect perhaps a deferral or a reduction in monthly fees, consider increasing certain expenditures in light of the pandemic, and essentially creating a deficit in the current year. You have to remember, however, corporations are going to be faced with higher costs in this situation. We're all hearing about cleaners coming in and doing special cleaning, perhaps additional security being hired. All of these things have to be considered when a budget's being revised. One of the largest costs in a condo is utilities. We just heard today, as Rod said, things are changing by the minute, that the government is providing some relief to all homeowners related to billing rates in Ontario. But will that be enough? The problem is that if there is some government relief and payments are deferred, how do utility providers provide us the services that we need in order to have electricity, for example? Will the governments be giving them any additional relief. If you are considering revising your budget, one of the things you should look at perhaps is what variable costs can be deferred, bearing in mind that you don't want to affect the marketability or the health and safety of the owners there. This is, just an ongoing problem. Another issue is, will vendors perhaps give you some deferral of payment so that you can reduce your costs? If you are revising your budget, one of the things you have to remember is that corporations on a periodic basis have to now issue what's called a PIC. If a budget is being revised, you have to issue a new PIC and also send out the new budget to all owners. So there's some additional costs related to that. We are, as everybody has realized,
let me just jump in, Brian,
Yep.
just for our listeners. The PIC being the Periodic Information Certificate, which is mainly a reality in Ontario, and those need to go out at least twice a year, or if there's a change, which is what you were talking about. I just wanted to sort of spell out the acronym PIC,
No
Periodic
problem.
Information Certificate.
Okay.
Go on.
Sort of the last piece of this is that, there's circumstances, not in these times, in normal times, people have to realize that expenses do come in greater than budget and create a deficit in the year. So those are all things that have to be considered if a corporation's thinking of adopting a new budget.
Okay, very good. Denise, there's been a lot of talk about maintenance fee holidays or deferral agreements, and can you shed some light on those?
It's definitely something that I do not recommend, and I think one of the issues is that there was an article in the Toronto Star, and it was a specific condominium that I'm aware of that had the ability to defer a month's common expense, but really all it was a payment plan for the owners, if they chose to opt into that, to make payments over the next several months for April's common expense payment. But what that did is got everybody talking about deferring common expenses. And I really think that it is way too premature. That by doing so, it could have severe repercussions. As you heard Brian talk about, we don't know what the budgets will say at the end of the year. What you don't want to do now is start deferring common expenses. We have to remember that prior to this whole COVID-19 outbreak, we have been dealing, and I know management, Sandy and Catherine, you know, that sometimes you make accommodations for specific owners. And you could do that either after or before the lien is registered. You want to maintain your priority and your security of your common expenses, but you make accommodations, you make payment plans, and you do that on a one-off basis. And that's exactly how I think you should do it. You need to keep the cash flow going here. That is so important, especially during these times. So let's just wait a couple of months, see how things go. There are other options, and I think Catherine's going to talk about this. You know, there may be savings for unit owners that could help them pay their maintenance fees.
There are a few things that have been announced specifically that will impact on homeowners, and you know, we don't know the details of them because the announcements have been made so recently. So the big six banks have talked about mortgage deferrals, and that is something that folks apply for. And there are also some short-term loans that can help folks bridge the gap. Most recent announcement in Ontario, of course, had to do with electricity. And it was much touted, it was much welcomed, and of course God is in the details, or maybe the devil in this particular circumstance. And one of the things that we have to look at is the fact that the discounted rates, the announced 10.1 cents per kilowatt hour, only applies to time of use billing. And so there are plenty of condominiums who have bulk bills and they are not time of use billed. Time of use billed, of course, is 3 different price points during the day. The 31.8% Ontario energy rebate does still apply. That is wonderful. This announced change in rate is for the duration of the order, which at present is expected to be about 45 days, but of course that could be longer. There is no application that's required if you're one of the people who will be able to take advantage of this kind of a rebate discount. It will show up automatically on your bill depending on your cycle. It might not come on the most recent bill, it might come on the next one, but it will be credited. The next question is, of course, what happens with sub-metered units? If it is billed by the utility on time of use, you will automatically again receive that rebate. If you're rebilled by one of the sub-metering companies, and there are a number of them, the way that bill will be treated will be dependent upon what the bulk meter looks like. And that may or may not be something that you know, but if you take a look at your bill, your last one, it'll show you what your rates are, and you'll be able to tell from that whether you have time of use or whether you have what is common perhaps in bulk metering is the Residential Price Protection Plan, RPP. And RPP does not apply for this program. The other one that doesn't apply to this program is the HOP plus GA, which is the hourly Ontario energy price plus local adjustment, which means a change in rate that is based on the actual cost of producing hydro. There was, of course, a mini budget or a fiscal update that the Government of Ontario released this afternoon, literally at 4 o'clock. So not really enough time for us to digest if there were any specific measures that might apply to condominiums in that announcement. Frankly, we weren't anticipating any, though we would really like to see some. The one item that has already been announced, and it is only specific to condominium corporations that have employees, there is a deferral of some of your remittances in consideration of your employer remittance values that you can apply for. And there's also a deferral of the EHT, employer health tax. But again, that would apply only to condominium corporations that have their own in-house staff, not contracted staff members. I echo very much the sentiments of Brian and Denise. My concern is that we're getting a really big, really hard knee-jerk reaction to worry as opposed to reality of what some of the financial impacts are going to be for homeowners. I'm hopeful that they will be able to take advantage of the funding that is available to support, people with childcare concerns right now, people who might be laid off, extended EI benefits, mortgage deferrals. The reason why I believe all of those programs are in place is because the day-to-day bills have to be paid. And the problem with the condominium corporation is it's all day-to-day bills. The second problem, and I really do feel for boards because it's a terribly difficult position to be in. There's no profit like at the bank for lending money. And frankly, you're not entitled to lend money. Your job is to collect the money and use it for the day-to-day operations and the major repair and replacement of the corporation and its assets. It is a duty and a covenant that you have to all of the neighbors that you're supporting under the one roof. And I'm most concerned that what we're doing is kicking the can down the street and we're making a really bad, really crippling choice that's going to have long-term financial implications. I also don't think there's an immediate need to take a look at this. I'm hoping that, again, we'll have a better opportunity to evaluate if we take a little bit of time.
Okay, thank you very much.
Just to summarize, I just want to summarize just a couple points. So, unless there really is some government relief, owners are still obligated to pay their fees. And it doesn't stop even, as we've discussed, if certain common areas or shared facilities are closed. Corporations still have obligations on a day-to-day basis, like Catherine said, to meet all their bills, and any of these type of fee holidays or deferral programs are just going to cause serious cash flow problems for the corporations. Corporations do still have the ability lien if fees aren't paid. We're going to get into that a little bit later. Those are my other comments in this area here.
Okay, something we haven't spoken about yet is a corporation's ability to borrow. David Plotkin from Gowling WLG, some comments on that?
Yes, for sure. This has come up in questions quite a bit now because with all of these emergency measures that corporations are dealing with, there's a lot of question is, okay, how are we going to pay for these things? And one of the benefits, let's say, of this time is that borrowing rates are quite low. But that, with all of that in mind, it's extremely unadvisable right now for corporations to be borrowing for anything that has not already been set aside in its budget. It's actually prohibited under the Condominium Act. If we look at Section 56.3, it's very clearly stated that a corporation shall not borrow money for expenditures not listed in the budget unless it passes a bylaw. And as we know, passing a bylaw requires calling a meeting. It requires a 50% plus one vote on that, and just the inability to call that meeting is in and of itself a reason not to go down the bylaw route. And as all of the things we've been hearing from Brian, you have to be extremely careful with the use of funds now, where the source of funds is coming from, what it's already been earmarked for, and not creating new headaches for the corporation and for the auditors down the road.
Okay, and I guess so. Go ahead.
Just adding
Brian.
to that, I mean, we're talking about borrowing and budgets and stuff. In our portfolio, we do see some corporations that have established contingency funds, and those are set aside for unusual expenditures or expenditures that don't qualify for reserve fund. And this is probably a perfect time, if there is any contingency funds available and corporations are starting to run short on cash, to start using those contingency funds. You don't need a borrowing bylaw. You don't need to think of using any of your reserve funds. It's really a good opportunity if they have those funds available.
Okay, on the question of the reserve funds, Denise Lash, what can you tell us about whether or not it's advisable or permissible to delay a Condo Corp's contribution to its reserve fund?
Okay, but before we get there, I just want to comment on the borrowing bylaw, because there may be instances in which corporations already have the authority to borrow. So we want to caution people now. We're not recommending that corporations borrow money, even if you have the authority under your bylaw. So let's move on to reserve funds. A lot of questions and a lot of scary comments about corporations wanting to use their reserve fund to fund their operating expenses or possible shortfalls, or doing it on a temporary basis. I got a call this afternoon from Stephen Chesney. I also discussed this with Brian, and I think they're both in agreement that common expenses in the budget allocate a certain portion towards a reserve fund. And that reserve fund portion should be allocated to the reserve fund. Allocating it to operating expenses is going to pose a whole host of problems. You're going to have a shortfall in your reserve fund. If you want to change your reserve fund contributions, then you need to do a new reserve fund plan, but not taking that money that's allocated for a reserve fund and putting it in the operating account.
Okay,
Agreed.
Very useful. I guess another question, let's change topics very slightly, it's still related. How do we ensure our contractors are being paid? And specifically, I'm wondering, what's the protocol to be followed when issuing a check, when signing a check? I know in many cases, condo corps have a signature from management and a signature from the board. Has that changed, Sandy, in any way, shape, or form?
Well, not yet, but there are concerns with that. So if your management company signs both portions of the check, not a problem. All your condo payments will continue. But right now, if board members are signing checks, things are that much slower in getting things to buildings right now. Couriers are working slower. So we need to start thinking about alternatives, even just for the short term. sending GLs out to the board so they can review what the payments are going to be made, and then they can authorize the management company to sign both portions of the check. Things to think about as this progresses.
Okay, and I think it's important to do things properly. It's important for the board to continue to have its oversight fulfill its oversight duties and be well aware of what checks are being signed. And I think it's additional work maybe for management, but you want to send all the documentation to ensure that it's very clear what's being signed, what's being paid, and you may also want to put in place to hold a board meeting remotely if required, just to sort of approve this new method of dealing with these ongoing expenses.
Yep.
You want this to be properly minuted. What have we changed in our approach, and for how long, and what sort of safety precautions do we put in place to ensure that, of course, all the money is accounted for and that everybody stays in their lane and do what they need to do. Brian, did you have anything to add on that?
No, I mean, all of those things you're talking about are best practices that should be done. I mean, it's even more important now that internal controls are maintained. So, I would never recommend that management on its own sign checks. There's lots of ways to ensure that authorizations are kept in place, that approvals are made so that checks can be sent out on a timely basis. One of the things corporations can start considering, though, is perhaps implementing some form of electronic payments as opposed to cash. Just something to consider.
Okay. And the last topic, I guess, with respect to financial questions, is because we're running out of time here. I guess we'll have to reconvene next week. But I want to talk about liens and collection processes. There was a flurry of activity on social media in the last couple of days, and this is because on Friday in Ontario, an order in council was issued, basically suspending limitation periods and suspending deadlines for procedural steps to be taken in proceedings. And so there was a lot of questions around that, whether or not that suspended the time frame that corporations have to register a lien. As most of you know, in Ontario, the lien must be registered within 3 months of the first of when the default first occurred. So if somebody skips January, you have to register your lien before the 3rd month anniversary. And if you don't register your lien by then, the lien expires. Or maybe stated otherwise, whenever you do register your lien, it will only cover the prior 3 months. So you need to register your lien within the 3rd month of that first default. And if you do register your lien in time, you have a priority over mortgage lenders and so on. So that's the basic premise. If for whatever reason you consider not register the lien, you risk losing the priority. When you do register a lien eventually, you may have lost a couple of months. And so the discussion that took place with respect to the order in council was, well, has that been suspended? Will we be able to register a lien much later on? I mean, there's probably 2 schools of thoughts out there, but I think the consensus is that if there's any doubt in your mind, register the lien. Why would you take that chance? Why would you postpone registering a lien and then have a fight with a mortgage lender down the line? The reality is that the situation is not going to get better for these owners who are unable to pay right now. Whenever situation gets back to normal eventually, their credit cards may be maxed out. They may have skipped some payments with respect to their mortgage. And so our recommendation, it's our strong recommendation, is do register your liens in time. You don't need to be overly proactive about it, but certainly before the 3 months, the 3rd month anniversary. And then it's up to you to see how proactively you want to try to collect on that. But at the very least, you'll have placed your priority on title, and you'll have priority over the encumbrances, such as the mortgage lender. Denise from Lash Condo Law, anything to add to that?
Yeah, I just want to add it because we have to remember that management companies have management agreements, and their management agreements require that they take steps to preserve those arrears within 3 months. So if someone's telling a manager to wait the 6 months because they think the order applies, there's going to be an issue. because it would be in breach of the management agreement. So I agree that let's just stick to the 3 months for now. There's no reason to extend beyond that.
Okay, a question that keeps coming up, and it's because we skipped it inadvertently, is what do we do with open houses? I mean, it's the chat room is ringing off its hook. Denise,
Yeah, I know.
anything to say about that, about open houses?
Yeah, it's interesting. You know, I was surprised to see that it's real estate agents and that business is considered an essential service, which means that showings can still occur, but protocol has to be established. So open houses. I think that we could take the position, sometimes it's in the condo docs already, prohibiting open houses, but if it's not, still take the position that it is prohibited. You're not doing anything to hinder the sale, but you're just not permitting an open house. There are a lot of agents now that are doing virtual showings, so that's fine. And then they can have purchasers come and view the unit one by one, and they should be setting their own protocols to make sure that that social distancing is maintained. So you cannot stop these sales, but steps can be taken to prohibit the open houses.
Okay, so it's been an hour and 15 minutes. We're in overtime right now. And I'm going to go around the table one last time, but in the meantime, Graham, if you see any sort of very pressing question or repeated question, maybe when we get to you, you can maybe put it to the panel. But in the meantime, I'm going to do one last round around the table, and I'm going to start with you, Brian Antman from Adams and Miles LLP. Any sort of parting words, words of wisdom?
I guess boards just have to be cautious in implementing any of the things we're talking about today. You want to consider all the consequences, speak to your professional advisors, and I guess the bottom line for me is we don't want to compromise the financial health of these corporations. They have to continue to be viable entities.
Okay, very good. Sandy Fold from Wilson Blanchard Management. Any
Sure.
parting words of wisdom?
Yep. Everyone has a role to play in flattening the curve right now. Your property management companies will continue to work with you to accomplish these goals. Boards and management should be taking reasonable steps to mitigate risk to staff and residents in these uncertain times. The underlying principle is physical distancing to stop the spread. Please respect the guidelines, respect your neighbors, and be kind to each other. We will get through this if we remain calm and use common sense, and wash your hands.
Nice. Catherine, go. Words of wisdom from ACMO?
I echo all of those sentiments. Be kind, be patient, be thoughtful. Lots of boards want to kind of push us up against a precipice and then make an emergency decision. And I think we're all best served if we use a lot of thought, take careful consideration of what the longer term impacts are going to be. And we have the breathing space to be able to have those conversations and to put that effort into our planning.
Okay, thank you. Denise Lash from Lash Condo Law, and also on behalf of the Community Association Institute Canada, any words of wisdom?
Well, I'd just like to calm everybody down. I mean, residents are living in fear. There is a lot of hysteria. And I think what management has been doing, which they're doing an excellent job, is communicating to residents. The communication is key here. Let's calm everybody down. Let's follow public health guidelines, and let's try to continue maintaining our operations like we always have been.
Okay, thank you. David Plotkins from Gowling WLG.
Yeah.
Words of wisdom before we part?
For sure. Continuing on the being reasonable theme, for lawyers, this is always a big thing when we're looking back in time and someone comes to us down the road and this issue happened. We always want to see who was reasonable and who wasn't. So continue to have your policies in place and continue management and boards to paper any issues that come up, because some of these things will need to be dealt with afterwards, and continue to be reasonable so that we can show any reviewing court afterwards that we all tried to do our best in the situation that we're currently faced with.
Okay, Graham McPherson aka Luke Skywalker from Gowling WLG. Any words of wisdom?
Yeah, I think I'll kind of tag on to what Denise said in terms of, people are scared right now and there's a bit of hysteria. So I think kind of on a more human element, just remember during this time, if you know anyone who lives alone or if you who maybe, just needing you to reach out right now is a good time to do it. Stay connected to people as best as we can while doing our part to flatten the curve.
Okay, thank you so much. So I've put up on the screen, I don't know if we've lost it because I've lost it here. I've put up on the screen a screen print of a Condo Advisor blog. I want to attract your attention to the top right. There's a new tab, a webinar tab, and that's where we're going to keep posting next webinars. And you'll have to register again. You would find there the topics, the speakers, and you would find there the registration form. And so go and visit that regularly, well, as regularly as you want to, if you want to see what's next. But I think looking at all the questions that came on the Q&A and on the chat channel, we're going to be again together in a week from now, same place, same channel, same people, same time at 5 p.m. on Wednesday, April 1st. And if in the meantime there's any sort of pressing topics or topics you'd like us to cover, by all means, we encourage you to send us emails. But as I said, if you want information about the webinars, that's where you get it and that's where you register. I'd like to thank everybody. I'd like to thank the panelists for sure for their leadership and for being so generous with their knowledge and their advice. And I'd like to thank all of you at home who have stuck around until now. I mean, it's been an hour and 20 minutes. Thank you very much for taking the time out of your busy lives to try to educate yourself, try to get information that will help you keep your corporations operating safely and that will help you keep your community healthy and safe. And so that's it. I'm Rod Escaola from Gowling WLG. I'm wishing you well, be safe, stay healthy, and be good to one another. Thank you very much. Good night, everybody.
Thanks.
Good night.
Bye.
Night.
Good night.